So the second area is using the information. So for patents, you're not allowed to make, use, or sell a product covered by the claims of a patent or practice a claimed method if somebody has a patent on something. For copyrights, it's really about copying the work itself, as we know, distributing the work. Now we turn to personal data. We try to make I've tried to make an analogy here. So for personal data, it's processing the data. What do you do with the data? You can process it. If you, whether or not you have the permission to do so is the same as whether or not you have the permission to make a product under somebody's patent. So I kind of see that as an analogy. So doing something with the data is processing it, analyzing it, using it to draw conclusions, or making predictions using an artificial intelligence engine or model, for example. You're making use of that data, and we've already heard from Valentino about the interface between artificial intelligence models with data that could be included in that model. So you really, like with patents, where you have a license to use that material, you could have a license to use the personal data within an artificial intelligence model, for example. So the third area is the originator of the protected information. So with patents, it would be the inventor. Who originated this this information that's being, or this concept that's being protected? The inventor, if it's a patent. Copyright, it would be the author, of course. For data protection, we have something known as a subject. So that's, I see that as analogous with the inventor of a patent, or the author of a copyright. So the person to whom the personal data relates to, it could be somebody's name, birthday, birthplace, your photo, or a video that you've made of yourself. This is similar, I think, to an inventor inventing a patentable invention. The fourth area is a third party who is not that party that originated this information would need a license or permission to do something that's protected. Like for patents and copyrights, you would be an infringer if you didn't have the right to use the intellectual property and you used it anyway. For data protection, this third party is called a processor. So if the processor is doing something with someone else's personal data, that's kind of like a license. A third party who did not come up with the intellectual property, but they have permission to use it as a third party licensee. The processor is the equivalent there. So I think I'm trying to make analogies here between IP and data protection.